Hello, everyone, and welcome to today's webinar, The Employment Rights Bill, Preparing for a New Era in Workplace Compliance. My name is Naomi Grossman, Compliance Manager here at VinciWorks. Thank you for joining us as we explore the significant changes coming with the Employment Rights Bill 2025 and what they mean for this new era of workplace compliance. So when we put this webinar in the calendar, I think we all thought it would have become law by now. But as you probably saw in the news, this bill has not yet become an act. We are stuck in parliamentary ping pong at the moment. But don't worry, because we will explore exactly what that means with our compliance experts who are with us today. I want to welcome Nick Henderson-Mayo, Head of Compliance here at VinciWorks.
Hi, Naomi. And as you mentioned, we are stuck in ping pong. It actually feels a bit more like deadlock, but we will get into how and if there is a way out of this, and whether or not the legislation will make it through unscathed.
Thank you for that. And we're also joined by VinciWorks training expert, Raquel Shepson. Raquel, great to have you with us and get your thoughts on how companies are supposed to manage the complexity of all of this.
Thanks, Naomi. You're right. So there is complexity over how many changes are coming to the workplace, HR, and health and safety compliance. But there's also uncertainty on when this actually is meant to happen. So it's not really an ideal situation all around.
Yeah, it's not an ideal situation at all. But that's why we're here today. We're here to explore what's supposed to happen, when, and figure out how this standoff might end. But we also really want to hear from you. Please feel free to submit your questions at any time using the Q&A function of the chat. We have a team monitoring them, and we'll try to answer as many as we can, either during the flow of our discussion or in the Q&A segment at the end. And if we don't get to your question today, we will put all the answers on our blog in the coming days. So please keep an eye out for that. Also, if you are interested in how VinciWorks can help with your compliance, you can write demo into the chat at any time. So we do have some other webinars coming up in the next few weeks, and links to register for these webinars are coming up now in the chat. The upcoming webinars are next Wednesday, November 12th. We have a webinar on GDPR. Now, if you're a law firm, then you're warned to join our special webinar on December 3rd about the upcoming change from the SRA to the FCA as a single AML regulator. Really big news for law firms, so you'll really want to join that one. And then join us on December 10th. We'll have a look ahead at the key compliance issues in 2026. Yes, it is almost 2026. Hard to believe. Okay, so with that out of the way, this new employment rights bill is supposed to be one of the biggest overhauls in UK employment law in decades. It introduces a host of reforms, from guaranteeing hours for zero-hour workers to giving employees new rights from day one on the job, bolstering whistleblower protections, bringing in new sexual harassment requirements, and setting up a powerful Fair Work agency to enforce all these rights. That's a lot of change, and it's going to reshape how organizations manage their people and ensure a safe, fair workplace. But we can't get started with any of that until the law passes Parliament. And that's proving really problematic. Nick, what is the holdup?
Thanks, Naomi. So as we said, the bill has not become law yet because it's been bouncing back and forth in what we call ping pong between the Lords and the Commons, the two houses of Parliament. So essentially, the House of Lords has pushed for a number of amendments and changes to the bill during their review. Now, these are the amendments that the government didn't want to include originally. And last week, the bill returned to the Commons. The government rejected all of those changes. And then the bill then went back to the Lords, where the peers voted overwhelmingly to put those amendments back in. And these votes were by pretty big margins, with majorities of between 140 to 150 from the House of Lords, to keep fighting with the government over some of the most contentious issues in the legislation. Now, it's really important to remember that the government does not have a majority in the Lords. The Conservatives are actually the largest party, and they've been working with the Lib Dems and some crossbench peers to oppose various parts of the bill. There was a thought, really, that the Lords would back down after making some of their points in the last few weeks, but last week's votes showed really they're doing the opposite, actually. They're bedding down in their opposition to some of these contentious parts of the Employment Rights Bill.
Wow. Really a lot to take in. Raquel, what are the contentious issues then between the Lords?
So the contentious points boil down to a few key areas. One big debate is over unfair dismissal rights. So the bill aims to give employees protection from unfair dismissal from day one of employment, and the Lords are actually opposed to that. Another flashpoint is the 0 hours workers provisions. So the Lords wanted tweaks to how guaranteed hours would work. So like refining the qualifying criteria, for example, how long someone must work a regular pattern before they're even entitled to a guaranteed hours contract, and clarifying exceptions for seasonal or casual work. There's also been disagreement on some trade union reforms, things like the rules around union political funds and how unions access workplaces. So whether Lords want changes to what the Commons had actually approved.
Thank you for that. So given this back and forth, what are the possible ways out of the stalemate? Like, is the government likely to compromise on some of these amendments to get the bill through, or do we expect the Lords to back down eventually?
So there is a few scenarios for resolving this deadlock. One route is compromise, where the government might decide to give some ground on one or two of the less critical Lords' amendments to placate their concerns. That could mean tweaking the language or the scope of a provision. For example, it could mean adjusting the implementation timeline for guaranteed hours or unfair dismissal to maybe meet the Lords halfway. Now, oftentimes for other pieces of legislation, just a small concession can be enough to get the Lords on board and let the bill progress, but I don't think this is very likely in this situation. The Lords who are opposing the day one rights believe this is the most damaging element of the legislation for employers. The government lost the vote in the Lords on allowing workers to take employers to tribunal for unfair dismissal from day one of employment by 301 to 153. So that's a majority of 148 in opposition to those day one rights. And I don't think a suggestion of a compromise will cut it.
Wow, you're probably right. So what are the options here, Raquel? Like, could the Lords back down?
Great question, Naomi. So it is a possibility, of course. There's a long-standing convention in Westminster called the Salisbury Convention, which basically says the Lords won't block a policy that was in the governing party's election manifesto. A lot of the bill's key reforms were promised in Labour's manifesto. They've made their point by proposing changes, but if the Commons remain steadfast, the Lords could bow out gracefully and let the bill through in its original form. But this would require the government to remain steadfast, and it's an open question if the government have the will to keep fighting over something so high profile. The former Deputy Prime Minister, Angela Rayner, was the bill's most high-profile champion, and she resigned from government last month. Plus, as Nick said, the Lords don't seem very keen to back down at the moment.
Right. And so what happens then if neither side gives in? Like if the Lords keep insisting on these amendments and the Commons keeps rejecting these changes?
So there is a legal mechanism for situations like this called the Parliament Act, and that allows the House of Commons to bypass the House of Lords and force a bill into law without their consent. However, it is a kind of a nuclear option, and it can actually only be used if the bill is reintroduced in the next parliamentary session and then passed once again by the Commons. So in practice, that would mean a delay of at least around a year before the law would even start to take effect. And because of that delay, governments very rarely use the Parliament Act. Last time was in 2004 for the Hunting Act. And it is really seen as a drastic step and kind of suggests there's been a breakdown in cooperation between the two houses. I also think if the Parliament Act is eventually used to force through this bill, it makes it much more likely that a future government that's not Labour might repeal it, because using the Parliamentary Act, using that nuclear option really makes it more contentious than it already is, and almost guarantees that this would be a sticking point or point of contention in the next election. There is a fourth option, actually, where no agreement is reached and the government doesn't use the Parliament Act, and then the Employment Rights Bill just fails. We might then see the government seek to pass some of the individual parts through smaller laws, but that would, of course, take much more time. We'd have to start the process all over again.
Wow. So in short, we're either going to see a compromise to some elements around day one rights, 0 hours, and trade union rights, or the Lords back down, or the government forces it through, but not until next year. So who knows what's going to happen? And let's hear from all of you here. What do you think will happen next? This brings us to our first poll question. What do you think will happen with the Employment Rights Bill? A compromise is reached, the Lords back down, the Parliament Act is used, the bill fails, or not sure. So we really want to hear from all of you. What do you think? What do you think is going to happen with the Employment Rights Bill? And tell us in the chat what your thoughts are. What would you like to see happen? So in the poll, tell us what do you think will happen. In the chat, tell us what you would like to see happen or any other comments you have about it. We want to hear from you. So again, the poll question, what do you think will happen with the Employment Rights Bill? A compromise is reached, the Lords back down, the Parliament Act is used, the bill fails, or you're not sure. Interesting. Oh, really interesting results. And we're getting some comments in the chat that are also interesting. So 40% of you believe that a compromise will be reached. Only 3% of you think the Lords back down. 12% of you think the Parliament Act is used. 21% of you, almost a quarter of you, think the bill fails. And 25% are just not sure. So really interesting. And some of you have interesting comments in the chat. You'd like to see a compromise. Someone thinks continue to stall as the budget will take priority space. That's interesting. Someone says they would like to see all businesses be consulted first. Would be a nice option. And others of you also would hope to reach a compromise.
I think just one point on the compromise, which is really interesting. If there is a compromise, we obviously don't know what there'll be a compromise on, but if that is the case, then a lot of the guidance that ourselves and many other people have been producing on what we expect to see will have to change. So just to be aware, if we get a compromise, if we get the bill passed, then what we've been expecting to happen, we might have, we'll have to kind of review and revisit that. So we'll need to then get back and up to speed about actually what the compromise looks like, because who knows at this point.
It's really, really an important point. Thank you for that, Nick. Thank you. So we've also produced a course on the legislation itself, and we're going to see a clip from the course talking about how employers can prepare. So we're going to go to that clip right now.
There's still a chance that a lot of things might change. So I guess my advice would be to employers, don't make loads of knee-jerk changes now, because things like morph and shift and change. But the things that you can do, I would focus on your policies and procedures, have a look at what they look like. Is there anything that you think might need to change going forwards, or are there things that you're not doing? If you're an employer that's got 250 employees plus, there's something coming down the line around menopause. So what could you be doing now to be getting ready for that? One, because it's just the right thing to do, but also because something's coming down the line.
One example is the potential expanded disability and ethnicity pay reporting. Many employers do not collect this data or collect this data in a very patchy way. It would be sensible for employers now to start thinking about how they may go about collecting this data. Voluntary reporting, certainly of some elements, may come in 2026. And we may then have mandatory reporting in 2027. Similarly, with the equality action plans, those are expected to come in on a voluntary basis in April 2026 and to be enforced from 2027. So employers really need to understand what those plans mean for them and what they need to do to implement them.
I think with unfair dismissal, people should be more cognizant of the way they bring people into their business, but not just because unfair dismissal is changing, just because as a business you need to be cognizant of the fact that you spend a lot of time recruiting people, time and money, so you want the right people in the right places. So I would definitely say have a look at your recruitment processes. Have you got some proper structure there? Have you got clear interview questions? What does that look like to make sure that you're ensuring you've got the right people in the right place at the right time?
What employers should be doing in terms of both the 0 hours contracts and also the new provisions around notification when cancelling shifts is they should really be doing an audit of their workers now and understanding what individuals they have on 0 hours contracts, what individuals they have on shift work, how often those shifts fluctuate, how frequently they cancel or amend those shifts, and what their current notification provisions are. The more employers can do to get ahead of the likely requirements of the bill, really just get their arms around their workforce and understand where the potential pressure points will be once the bill comes in, the less work they will have to do at the last minute.
Thank you. So that was a clip from the course on the Employment Rights Bill. We have a whole host of modules on not just the bill, but also so many parts of legislation that aren't in contention, from sexual harassment to equality reporting. So if you want to see more about any of that, you can write demo into the chat now. So let's now turn to explore some of those non-contentious issues in the bill. The first is the changes to sexual harassment. Raquel, we have the Worker Protection Act in place. How does the Employment Rights Bill change that?
Good question. So we can see the Employment Rights Bill as essentially superseding the Worker Protection Act. Firstly, it strengthens the existing framework by requiring employees to take all reasonable steps to prevent sexual harassment, raising the standard from the previous reasonable steps. So that basically means that the list of reasonable steps you came up with during your Worker Protection Act assessment should definitely be reviewed. And you should put in place all of those which are reasonable instead of just some that kind of previously were reasonable. Next, there is a liability for third-party harassment. Employers would be held accountable for harassment perpetrated by third parties if they fail to take all reasonable steps to prevent it. So that means customers and clients and possibly even members of the public. Another interesting addition is protected disclosures. So these are disclosures related to sexual harassment that would be classified as protected disclosures, safeguarding employees from retaliation and rendering non-disclosure agreements unenforceable. It gives the same protection as a whistleblowing complaint. And finally, the Employment Rights Bill establishes the Fair Work Agency, which will be a new regulatory body with powers to investigate and enforce compliance with employment laws. The government actually announced the appointment of the chair of the Fair Work Agency last week, Matthew Taylor, who was actually head of policy during the Blair government and also warned about the risk to workers' rights from the gig economy, so he'll be in charge. In my opinion, the appointment of Mr. Taylor to the job really shows the Fair Work Agency's intends to use its powers to issue fines and bring cases on workers' behalf.
Thank you. It's really, really interesting. And Nick, how does the Equality Act fit in with all of this?
So the Equality Act 2010 already makes sexual harassment unlawful and holds employers vicariously liable for harassment against staff unless they can show they took all reasonable steps to prevent it. But that test is actually reactive and only becomes relevant after a specific incident of harassment occurs. The Worker Protection Act of 2023 it amended the Equality Act by creating a new proactive duty on employers to take reasonable steps to prevent sexual harassment happening in the first place. And that applies specifically to sexual harassment, not other types of harassment, which the Equality Act also covers. And then it's backed by an enforcement power, which is a potential uplift in tribunal compensation of 25%, where an employer has fallen short. So to sum up, really, the Equality Act is reactive, but covers all aspects of harassment, whereas the Worker Protection Act is proactive and only covers sexual harassment. And in either case, having reasonable steps in place is a defense in an employment tribunal, and the Employment Rights Bill will increase all of that with the requirement to both be proactive and to take all reasonable steps.
Thank you. Thank you, Nick. It's really, really helpful. Okay, let's ask another relevant poll question now. And the question is, do you anticipate doing more to prevent sexual harassment with the forthcoming employment rights bill? You plan on doing a great deal more, just a bit more, going to continue doing the same, you're going to do less, or you're just not sure. So the question again is, do you anticipate doing more to prevent sexual harassment with the forthcoming employment rights bill? So do you plan on doing a great deal more, just a bit more, doing the same, doing less, or you're just not sure? Really want to hear from everybody here. What do you anticipate doing? Do you anticipate doing more to prevent sexual harassment with the forthcoming employment rights bill? Let us know, and let us know in the chat what you plan on doing exactly, or any comments you have on that. Okay, so really interesting. 11% of you say you plan on doing a great deal more. Wow. Now, 48% of you, which is almost half, say you're going to do a bit more. 32% say you'll continue doing the same. Only 0% say you're going to do less. 9% of you are not sure. So really, really interesting spread. Okay, Nick, just quickly, we had a question that came in that's interesting. Does third party count to other companies that you may share a building with?
Yeah, definitely a good question. Yes, that would count. A third party is really just anybody else. It could be someone walking along the street. But actually, perhaps the building management, so whoever's in charge of that building that you're sharing with other people, they would also have additional steps to take to prevent harassment. So whoever is running that building, we need to make sure that they have things in place to obviously prevent that. Maybe they need more CCTV, signs, ways to report things. So if there's shared corridors or shared bathrooms, then I think it'll be the onus really will be on the building management as well as the people inside the building and the companies inside it to make sure that there are different steps in place. So I think it's probably something to raise with the building managers themselves.
That's great. Thank you. Thank you for that, Nick. An excellent question, and keep your questions coming in. And also comment in the chat again what more you might be planning to do around sexual harassment given the employment rights bill. And if you're looking for harassment training that will automatically be updated with the changes once they come into effect, write harassment into the chat now and someone will be in touch with you. So thank you. And you can also download our FAQ to the Worker Protection Act and sexual harassment compliance in general, which is coming up in the chat now. A link to those FAQs are coming up in the chat now. So feel free and really keep posting your questions in the chat. They're great. Okay, now another crucial element of this bill is all about whistleblowing and speaking up. A strong safety culture really depends on employees feeling safe to voice concerns, whether it's about a slippery floor, a piece of equipment that's malfunctioning, or even misconduct like sexual harassment, what we were discussing right before. So the bill enhances protections for people who do speak up. Now, Nick, what's changing on that front, and what should companies be doing to foster a speak up culture?
So the bill does reinforce and broaden whistleblower protections. Now, in the UK, we already have laws that protect workers from being dismissed or penalised for making what are known as protected disclosures. And the bill, if it passes, will expand on those protections, and that will make it easier for workers to claim that they've been mistreated for speaking up, and that will emphasise areas like harassment as issues that people should report. Now, we might also see some new bodies or procedures set up, also to encourage whistleblowing. It's been on the cards for many years to make more of an effort to protect whistleblowers in the UK. There's talk of maybe a whistleblowing office, maybe a requirements for a hotline at government level. We don't have anything concrete as yet. We're expecting more consultations on the matter, but it does give powers to enhance whistleblowing and make harassment a protected disclosure.
Really interesting to see how this will evolve. Okay, Raquel, what are the practical steps we should just start to take now?
Really great question, Naomi. So Every company should have a known confidential way for employees to report concerns. This could be a dedicated email, a phone hotline, a third-party system, or even just an open door policy, but it has to be communicated. If nobody knows it exists, it just doesn't help. So during training or onboarding, you should just tell employees, if you see something dangerous or unethical, here's how you can report it. Also, when it comes to retaliation, it's one thing to say we won't retaliate, but you have to actually enforce that. Managers must understand that if an employee raises a concern, you can't punish them, no matter if it's about safety or reporting the manager themselves for something. The bill may impose harsher consequences on employers who do retaliate, so it's critical. And from a culture perspective, if people suspect they'll get in trouble for speaking up, they just won't do it. Then problems fester. So make non-retaliation a core part of your policy and actually live up to it. Beyond having a mechanism, encourage its use. So talk in safety meetings about the importance of reporting near misses or hazards. When someone does report something, thank them. Assume it's raised in good faith and let them know what's being done. Some companies even give positive recognition to employees who identify issues. You have to gauge what's appropriate, but the idea is to remove the fear and maybe even create pride in contributing to a safer workplace.
Thank you, Raquel. Those are great points. And a big part of that is just understanding the how of reporting, isn't it? Like also making sure those reports are followed up, because if there's a sense of them just being kind of tossed into the void, people will eventually feel there's just little point.
Yeah, exactly. And I'll add it's really important also to train managers specifically on how to handle a report. Because if an employee comes to a supervisor and says, I want to report something unsafe or harassment or whatever it was, the worst response is to dismiss it, get angry at the person. And we've seen those happen in so many different employment tribunals. That's what ends up happening in a lot of cases. So training supervisors, managers to respond with the proper way. As Raquel said, thank them for telling them, say that it's going to be looked into, explain to them what the process is going to happen next, and then obviously follow that proper process as well. And also consider situations where someone might be more comfortable maybe talking to a peer or some other designated person first. Some companies have things like mental health first aiders or champions. One of those champions, here's a bit an issue, let's say, employee tells someone and one of them that, they're being bullied, they're being harassed, it's making them stressed, then that champion should be empowered to either report it or to, offer assistance in raising it if they need to, rather than keeping it, confidential and just not sharing it anywhere. Obviously, they should know how to handle it sensitively, but the point is to get the concern to people who can address it. Make sure there are channels in place to do that. Silence is what we don't want to see.
Right. Absolutely. Such a great point. And the goal is that any genuine concern, whether it's like a safety hazard, illegal activity, harassment, whatever, gets voiced and dealt with internally rather than being swept under the rug or escalated outside because people just lost trust. And with stronger legal protections, it's an opportunity to really reinforce that culture. So if you're interested in finding out more about VinciWorks' own incident reporting system and the kind of features it offers, you can write system in the chat now and someone will be in touch after the webinar. Okay, we've talked a lot about having channels for people to raise concern. Let's take a quick poll on that. Now, question is, how confident are you about your organization's incident reporting system? Are you very confident, somewhat confident, not very confident, not confident at all, or just not sure? Again, the question, how confident are you about your organization's incident reporting system? And pop in the chat any thoughts you have about improving it, or what you don't like about your incident reporting system, or what you do. Really want to hear from you. Question again, how confident are you about your organization's incident reporting system? Very confident, somewhat confident, not very confident, not confident at all, or just not sure. Give you a couple more seconds. Okay, really interesting. 27% of you are very confident in your organization's incident reporting system. 49% are somewhat confident. 16% are just not very confident. Only 5% are not confident at all. And 3% of you are not sure. Okay, really interesting spread. Raquel, what do you think of these results?
So I'd say that's a pretty typical spread. A lot of organizations have a hotline or reporting system on paper, but the real issue is whether employees know about it and trust it. If you have low usage of your system, that could mean either everything's perfect, which I hope so, but it's unlikely, or that people are too afraid or don't actually think it will help. So it's worth checking the awareness and trust level, maybe through an anonymous survey or by looking at whether issues tend to be raised through other channels like whisper to HR rather than formally logged. For those without a formal mechanism, I strongly recommend creating one. It can be simple, even just a dedicated email address or a physical Dropbox, although ideally something that allows anonymity if needed. And then communicate and trade people on it. Make it clear that raising concerns is encouraged and safe, especially with the new bill's emphasis. Not having any channel at all could really, really backfire if something serious happens and it turns out employees felt they just had no way to report it internally.
Yeah, definitely. And just to add there as well, actually, it's a good idea to extend that to everybody who works for you, including contractors, temporary workers, because they might see issues too and may have less embarrassment about raising something. And whistleblower protections can cover them as well in certain circumstances. So it's really important to make sure that any worker on site knows how to speak up if they see any kind of safety issue, misconduct, whatever it might be. It helps everyone in the end if the issue gets flagged and fixed.
Thank you. Those are really great points from both of you. And it's all about creating an environment where no one hesitates to say, hey, this just isn't right, whether it's a safety risk or anything else that could harm people or the organization. Nick, we had a great question here about harassment I wanted to ask you. Someone asked if our global code of conduct sets zero tolerance, but we apply reasonable steps in the UK. Should the same approach apply across the UK?
So zero tolerance is a reasonable step. That in itself is something that is actually very, very good, reasonable step to say you have a zero tolerance approach to harassment. That is a step in itself. And then also what you want to do though is say, well, what happens after that? So someone makes a report, then is who's dismissed? How is it investigated? Where does the evidence come from? What happens if it's unsubstantiated? What does zero tolerance actually mean in practice? So that is a kind of the next level about putting those steps in place. Is great to have zero tolerance. That's fantastic. Make sure it's communicated. It's included in training. It's written on, posters on the wall. And then also what will happen in all the different circumstances that might come from that. So to sum up, really, that zero tolerance is a reasonable step in itself, but you want to have more, to explain more, to say more about how that will happen and what it will look like. And actually, whistleblowing is a really great additional step to say, yes, we have zero tolerance. How that manifests itself in practice and how we mitigate the risk of an issue happening is through communicating our whistleblowing procedures or incident reporting procedures. It's QR codes on the wall, it's on coffee cups, whatever it might be. So whistleblowing can actually help cut across lots of different compliance areas to show how you are promoting that in the workplace.
It's a great point. And actually, someone in the chat made a really good comment that's relevant to this. They said, until someone has to use a whistleblowing system, you really don't know how good it is. It depends on the company and the organization and the people behind it. So that's a really good comment. Thank you for sharing that. And if you're interested in VinciWorks whistleblowing training, write whistle into the chat now, and someone will be in touch. So let's move on. Although the legislation hasn't yet passed, the government has started already to issue consultations on some of the elements in the bill. One very important issue is around pregnancy dismissals. It's been described as one of the most far-reaching changes to dismissal law we've seen in years. Nick, can you walk us through what's being proposed and what it could mean for employers?
So this is a really, really significant development as part of the legislation. The government have opened this formal consultation called Enhanced Dismissal Protections for Pregnant Women and New Mothers. And this runs until 15th of January next year. And it is part of the Employment Rights Bill, even though we're not quite at the finish line yet. Now, the idea is relatively simple in theory, is to make it unlawful to dismiss a pregnant employee or new mother for at least 6 months after returning to work, except in very, very limited, very clearly defined circumstances. But in practice, actually, it can make it really reshape how employers handle conduct, performance, and redundancy processes involving pregnant women and new mothers. Right now, the Employment Rights Bill just gives ministers the power to make regulations that strengthen dismissal protections, but it does not define how those rules will work. And that's what this consultation is all about, deciding when will these protections apply, what will count as lawful dismissal if that needs to happen, and what evidence employers will need to have to prove the dismissal isn't linked to pregnancy.
Really interesting. And Raquel, what are the options in the consultation?
So essentially, there are two competing models. The first would keep the existing fair dismissal reasons. So this is conduct, capability, redundancy, but apply a tougher legal test, requiring employers to show that keeping the employee would cause serious harm to the business or others. The challenge is that serious harm isn't defined, so it could be really difficult to prove. The second option is more radical. It would remove certain dismissal grounds altogether during the protected period. So, for example, no capability dismissals linked to pregnancy-related illness, no conduct dismissals unless it's gross misconduct, and limited redundancy exceptions. In other words, dismissal would become the absolute last resort. There's also growing support for reversing the burden of proof, meaning employers will have to prove a dismissal wasn't linked to pregnancy rather than employees having to prove it was.
So what would this mean for employers?
Great question, Naomi. So it's going to make dismissals involving pregnant or recently returned employees extremely high risk. Managers will need to gather far more evidence before raising conduct or performance issues, because even a perception of unfairness could trigger legal exposure. Redeployment will move from best practice to a legal obligation, and record keeping will become critical. So you'll need to demonstrate that pregnancy plays no part whatsoever in the decision. From the moment pregnancy is disclosed, that employee will effectively have an enhanced shield that extends well beyond their return from leave. Dismissal will become the rare exception rather than the rule.
Thank you for that. Really, really interesting and important to keep an eye on. So now let's touch on some of the other consultations we're expecting to see. These are around workplace surveillance and right to disconnect issues. Now, Nick, what should employers be considering regarding after-hours communication and monitoring of employees?
So like with the pregnancy protections, the bill itself doesn't set rules on these, at least in the current draft, but it does signal that the government is intending to act on them and will likely set through further regulation in the future. But it is wise to think about it and get ahead of the curve potentially. So one of these is the right to disconnect. Now, this is a concept that is already law in some countries, particularly in France. It's about protecting employees' personal time. Now, even without a law, there is a kind of growing expectation on many companies to start establishing some guidelines around this sort of thing. So, maybe discouraging emails or work calls outside of normal hours, or at least making it clear that employees aren't expected to reply until they're back on duty. Some companies have even got server rules that stop emails, from sending at midnight. You don't necessarily have to go that far, but at least culturally, managers can lead by example by, not routinely sending messages to their team when they know it's a day off. And especially with the health and safety element, fatigue is obviously a very, very significant risk. And if people truly can disconnect after work, they will, more likely to come back refreshed and alert.
For sure. From a safety standpoint, I love the idea of a right to disconnect. Burnout and fatigue are real safety hazards, but if people feel they can truly shut off after work, their mental health improves and they're less likely to actually make mistakes when they're working. So even before it becomes law, businesses can champion downtime. Simple things like encouraging people to take their full holiday entitlement and not contact them when they're off unless it's an emergency, it really does go a long way.
Mm-hmm. Thank you. Thank you both. Really, really important. Nick, a question actually just came in that's really interesting. I don't know I'll just ask you if you want to take it now. What happens regarding employees who use harassment claims as a way to avoid what is genuine, reasonable performance management?
So this is a really live and important issue, and essentially you have to take seriously the harassment claim. It may be even that you might have to stop performance management issues until the harassment claim is being properly investigated, because this is where it can get really, really complicated, because maybe the person generally is being harassed at the same time of them having performance issues. Two of them can happen at once. So where these things start to get really complicated, I think it's a good idea to take legal advice, obviously, and make sure everything is documented and done in the exactly proper way.
Thank you for that. And it is a really, really important question. So thank you, and keep sending your questions in. So it's especially true for international teams and working in different countries where there are different holidays and cultural expectations around when emails or messages might be sent or answered, and communicating these kind of things will be really important. So another big change is around surveillance of employees. And Nick, can you tell us a little more about that?
Yeah, so with remote work and advanced tech, some employers have implemented some pretty invasive technology like tracking keystrokes, webcam monitoring. There's obviously a balance. Some monitoring is fine, even necessary. CCTV, warehouse, for instance, for security, GPS in company vehicles for route safety. But anything you do, it needs to be transparent, and you need to ensure it's justified as well. So if you're going to be monitoring email or internet use, you have to have a policy that explains that. We are moving towards more restrictions on employee surveillance from the government through this bill, and also other ones to come in the next few years. And one interesting angle is actually safety versus privacy. So using cameras or wearable technology to ensure safety in a lone working scenario might be really helpful, but you do have to communicate why you're doing it. So it's not just seen as, as surveillance for the sake of it.
Right. That's a great point. And it also necessitates some serious thinking around data protection, especially using something like smartwatches, which can incorporate neurodata or other really sensitive types of information.
That's a really important point to take forward, Naomi. Remember that any personal data from monitoring is subject to GDPR and data protection rules. The bill's future regulations will align with that, but it's worth auditing your practices now. So list out what monitoring you do, like CCTV or system logs, and check that it's all necessary and that you've told employees about it. If something seems overly intrusive with little benefit, consider maybe dialing it back. The government has hinted at requiring consultation with staff or unions about surveillance tech. It's good practice to do that anyway. If you plan to introduce, say, vehicle dash cams or location trackers for safety reasons, talk to employees or their reps. For example, explain the safety benefits and listen to concerns. Often you can find a solution that achieves safety and respects privacy, like maybe the tracker only triggers an alert if speeding rather than a constant location broadcast.
Thank you. Thank you, Raquel. It's really, really important points. Okay, let's see what our plans are regarding training on some of these different rights and responsibilities in the Employment Rights Bill. And we really want to hear from you in our next poll question. Are you planning to conduct training on these new employment rights? So yes, you are preparing new training internally. Yes, but from an external training provider. You're considering it, no plans to do so, or just not sure. So the question is, are you planning to conduct training on these new employment rights? Yes, we're preparing new training internally. Yes, from our external training provider. You're considering it, no plans to do so, not sure. And pop your thoughts in the chat. What kind of training, why you're planning new training, why you're using external training provider, why you have no plans to do so. We really want to hear from you. So again, the question, are you planning to conduct training on these new employment rights? Okay, interesting, really interesting. 20% of you are preparing new training internally. 6% of you are using your external training provider. 40% of you are considering it. 13% have no plans to do so. And 22% of you are not sure. So if you want to see more about VinciWorks training options on the Employment Rights Bill or any of the new rights involved, write demo into the chat now. Someone will be in touch. Okay, Raquel, how would we start to roll out a communications plan on the right to disconnect?
I think a simple email from leadership saying we encourage you to unplug outside work hours, and managers should avoid non-urgent out-of-hours communications. It can just set the tone. If you have no policy, now is a really good time to think about it. And if you already have one, ensure it's actually being followed and that people understand it, which is where training comes in. Even including a short module about it during onboarding training or sending out reminders can help to encourage adoption. I've seen companies with no formal policy, but where the managers lead by example and never bother people on weekends. So employees feel fine switching off. And I've seen companies with a policy, but certain departments ignored it. So it just really comes down to culture.
Such good points. Thank you. And there's so many aspects of the Employment Rights Bill and so much more, so much we can cover in just an hour. So that's why we've produced a really comprehensive guide to all of the critical health and safety related elements of the legislation. And that's coming up in the chat now. We will, of course, be issuing an updated one once the legislation has been passed, and we'll update you about that by email. So the link is coming up now. I would really highly recommend downloading this guide. Really, really comprehensive. Okay, we've covered a lot so far. Now, before we get to your questions, let's zoom through some of the other key points in the legislation. Nick, can you help us with that?
Yeah, so there's a really interesting strand in the bill around equal pay and workplace equality. And these reforms are intended to move the UK towards a more proactive model of equality. One that's not just about reporting, but actually expects employers to show what they're doing to close some of the gaps that have been identified. So under the legislation, larger employers will be expected to create and publish action plans setting out the specific steps they're taking to close a gender pay gap, for instance, and also how to improve menopause support in the workplace. Now, these are supposed to be voluntary from April 2026, although that's dependent probably on when the legislation does get passed. But the government has been really clear that if they see progress as being slow, they want to make that mandatory and potentially even by 2027. And what's important here is the emphasis on transparency and accountability. So we have had gender pay gap reporting for a number of years, but until now, you could just, kind of publish the figures and not necessarily explain how you're going to fix them. The new action plan model is supposed to move beyond that. So it will require companies to outline the goals, the timelines, and how they're tracking progress. So shifting really just from passive reporting to actually active improvement.
Thank you. And it's really interesting that menopause is included here also.
Great point. So yeah, this is the first time we've seen it elevated to the same level of importance as gender equality. Employers will be expected to set out how they're supporting menopausal employees. So this through policies, training for line managers, adjustments to uniforms or working conditions, and awareness campaigns. The government sees this as part of a broader drive to tackle the hidden inequalities that push women out of the workplace in their 40s and 50s. So taken together, these measures push employers beyond compliance box ticking. They also encourage a strategic, data-driven approach to inclusion, one that actually connects gender equality, health, and retention. These become mandatory in 2027. Organizations will need to be able to evidence not just that they've published a policy, but that it's actually working.
Thank you for that. It's really, really helpful. So let's have a look at another clip we have from the course now on some of these changes that are coming around equality reporting requirements. So we're going to go to this video right now.
At the moment, employers with more than 250 employees are required to produce gender pay gap reports, and there is consultation ongoing about extending that to ethnicity and disability pay reporting as well. Under the government's proposals, the gender pay reporting obligations will be extended to producing equality action plans, which will then require employers to set out in detail how they propose to enhance equality within their workforce, particularly around pay.
So you'll still need to do the gender pay gap reporting, but on top of that, you'll need to include menopause data as well. Now, we don't know exactly what that's going to look like, but it sees the government shifting a little bit more towards providing protections or just acknowledgement and awareness of menopause in the workplace. So putting something within the bill around that kind of signals that the government are bothered about it and aware about it, which is great, but also pushes employers to have more of a focus on it, because now you're going to have to start recording and being much more aware of those things. What's different about the bill is that it brings in a requirement to include contractors and freelancers. They don't have to include data in relation to those individuals. All you need to do is signal who the providers are that you're using for those services. So quite interesting, because you don't have to include information, but you do have to signal who your providers are. And I'm interested to see what the government actually does with that information.
So that was a clip from our course on the employment rights bill. If you want to see more about that, write demo into the chat now and someone will be in touch. So we had some interesting questions come in, and Nick, I'll just send some of these your way. Tell us what you think. Someone asked that it mentioned in the previous video about the changes applying to businesses over a certain size. Is this the case for the whole bill? Like, they have less than 100 employees, so they're trying to figure out how they fit into this.
It all depends on the different elements of the different rules themselves. So in that big guide that we produced around all the health and safety aspects, it will say where things are supposed to be for smaller or larger. Generally, 250 employees is the definition of a larger employer. So kind of if there are exemptions, it will usually be around the 250. But actually, there's not a lot of exemptions for smaller companies, really just around the pay gap reporting. I think menopause action plans are for larger companies, but all the other things like zero-hour contracts, day one rights would be for everybody. Obviously, that is if it goes through in its existing form, but really there isn't a lot of exemption for smaller companies in the legislation.
Really, really important. Good question, and important to know. So we'll just grab one other question before we move on. And this question is, what happens when the job is, for example, in hospitality, like restaurants or hotels? The manager has not enough appropriate training HR-wise, and there's always kind of a fine line between business needs, company culture, and just unlawful or bad practice. What happens there?
So the risk here is that someone will take you to an employment tribunal. That really is the kind of the main way to enforce employment rights, is that someone feels they've been discriminated against, they quit, they leave, and then they can claim constructive dismissal. What the legislation is supposed to do is allow someone to do that from day one of employment, meaning that they could join, on the second day they start to feel that they're being harassed, they're being abused, they're being whatever, then they don't come back, and then they take you to the employment tribunal, and then it'd be up to the tribunal, if it goes forward, to investigate, did you have all the training procedures in place to prevent that from happening? So this is where the risk really is. It's a long risk because it takes a long time to go through the tribunal process, but it is a real risk. And we've seen some recent examples actually with Lidl supermarket, where someone was left because of sexual harassment. They claimed unfair dismissal, they won, and actually Lidl was forced into an agreement with the Equality and Human Rights Commission to completely redo all of their policies and training processes for harassment. So one case can really lead to very significant outcomes and very significant changes. So this is why really firms want to make sure that they have everything they're supposed to have in place so that they can defend themselves if something does happen.
Really, really important. Thank you. Thank you for that, Nick, and thank you for the question. So now, as we've covered, some of these aspects of day one rights are still under contention, but what is the government's aim here with this legislation?
It's really, really strong on these family-friendly measures. It's really ensuring that entitlements to things like paternity leave, adoption leave, bereavement leave, they all become available from day one of employment. So there's no qualifying period needed. So someone starts a new job, and let's say all of a sudden they have a baby, there's a family emergency in the first week of employment. They're not supposed to have to worry about not having the rights to leave, because they would have immediately those protections and those expectations. There are also provisions for a whole host of new types of leave that people can claim: neonatal care leave for parents of premature or sick babies, That's supposed to be introduced so parents can take time off when they really need it for those situations. Also, in flexible working, the bill as it currently stands is supposed to strengthen that framework so every employee can request flexible working from the first day of the job rather than after 26 weeks, which is the current situation. And then also employers will have to take those requests a bit more kind of seriously and transparently. They'll need to actually discuss the options and explain a refusal very clearly instead of just saying, no, you can't do that.
Wow. Okay. And if the bill does get through in the current format, so we will have dismissal protection from day one as well?
So that is one of the headline changes here, so that the bill will remove the qualifying period for unfair dismissal claims. Right now, most employees need 2 years service before they can bring an unfair dismissal claim. But once this law comes into effect, every employee will have an unfair dismissal rights from day one of employment, and that's massive. It means employers must ensure any dismissal is fair and lawful, regardless of how long someone's been with the company. So on a related note, the bill is targeting the practice of fire and rehire. It will make it automatically unfair in most cases for an employer to dismiss someone and offer to rehire them on worse terms and conditions. This tactic, which some companies used in recent years to force through contract changes, will be effectively off the table, except perhaps in special circumstances. And for context, the bill also strengthens protections around dismissals in specific situations. So, for example, if a worker takes part in a lawful industrial action, firing them for that will become automatically unfair, which will remove the current 12-week limit on strikes protection.
Thank you. Really, all this is so important. And one question we've had in repeatedly. So Nick, I'm going to ask you this. What should be our top priority to tackle first among all these changes?
So it's really going to depend on you as your organization and where your risk exposure is. But I think the first priority is get your internal compliance in order. And so that by that I mean do a checkup against all of the bill's provisions. Are you tracking hours accurately for all staff? Because that's going to be really fundamental to know, especially if you have 0 hours workers. If not, maybe fix that part first. Then do you have a system to keep all the required records like holiday pay calculations, and can you keep that long term and access them easily? What about all your current policies? Do they mention things like 2-year service requirements that might not apply after the changes happening? Start to kind of update those. Essentially, finds the gaps really between what current practice is you're doing, and then the upcoming parts of the legislation. And I'd refer you back to the guide that we published and all the different health and safety aspects where you can map against what your current places are and where you might need to change once the legislation does come in.
Thank you for that really helpful advice. So, and Raquel, how do we deal with communicating all of these changes when there's just so much to deal with?
Great question. Once you identify the gaps, you can prioritize filling them in. So prioritize communication and training. Make sure leadership is aware of what's coming in. And senior buy-in is crucial because some of these changes might require budget. For instance, new software or potentially higher sick leave costs. And start educating your wider workforce. Managers need to know, as we've said, how to handle these new rights. Employees should also know their rights. In short, assess and educate. Assess your current state versus the future requirements and educate everyone involved on what's changing and why it's positive. If you do those two things, you'll be well on your way to a smooth implementation.
Thank you. Excellent. And these are great points to end on. So, okay, that's all the time we have for today. And I want to thank our expert panelists, Nick and Raquel, for sharing their expertise today. It's been a really enlightening discussion. And thank you to all our attendees for participating so actively. We really hope you found this session valuable.